time here at Widener. The second most practical course will be the bar exam prep. And you know, I've heard that mostly for another year or so. But it's great to be here. If you have questions throughout, just please raise your hand, and I'll gladly answer anything that you want to ask. If you want me to go in more detail about a case I mentioned or anything, let me know. This will not be a boring 60-minute class, trust me. When I taught at West Point, I prided myself, that was 11 years ago. I was age 27, and I was teaching constitutional law there. And I prided myself to say I was the most electrifying professor at West Point. But to get non-law majors to care about constitutional law was sometimes difficult, but we managed to get through. I serve on the National Advisory Committee for Widener Law School as well. I believe in the Widener family. And let me just, I know it doesn't have to deal with my lecture today, but I want you to know that whatever you choose to do with your law degree here from Widener, I think you'll find your time here in law school, although it's very tough as you're going through it. It changes the way you think about issues and problems, and really makes you so much more analytical and a skill set that you can't get anywhere else. And I will put the Widener law graduates against anybody in the country. I have competed against every other law school in the Army JAG Corps, which is the largest law firm in America, whether it's my law firm now, which is one of the largest law firms in Pennsylvania and the country. We have 550 attorneys. There's not a whole lot of Widener law grads that are at Fox Rothschild. We have a Philadelphia office, a Pittsburgh office. We have 16 offices across the country, but we're based in Philadelphia. That's the office I work at. I will say that we have 15 summer associates this year. I felt like that would make sure one of those 15 was Widener. Unfortunately, she's not at Widener Harrisburg, she's at Widener, Delaware. She's working out of her Delaware office. But we're working on that. Maybe next year, I mean, somebody there, because it's a great firm. Let me begin, and again, I will make sure this will not be a boring law lecture. But let me begin by just saying, whether you plan to be a trial attorney or not, this course is critical because litigation is always a potential, as you know, whether you're a litigator or not, when you practice law. If you draft wills for a living, in the back of your mind, you got to say, well, if my client isn't happy, or their children, when their client passes away, aren't happy, and you want to go to litigation, your work will have to be determined important. It'll be important for you to know what's at stake. I wish they made ITAP, frankly, mandatory for every single person, because the skills that you will learn in this course will guide you throughout law practice. I happen, as you know, most folks don't go into litigation. Most folks don't go to law school. You know, 25% of Americans get a college degree. 1% to 2% of them get a chance to go to graduate school. It's a little bit less than 1% get to go to law school. Of those that are the 1% go to law school, only 2% ever go inside of the courtroom. Most will never see it. Now, I have been blessed. I have tried cases in federal court, at military court martial. I will tell stories today about how I tried cases in the Supreme Court of Iraq. Got reprimanded by a Supreme Court justice in Arabic, so I didn't realize I was getting yelled at first until my interpreter told me. And making an argument basically based on the 1969 Iraqi criminal code, which I didn't even know existed when I was here at Widener. But those fundamental principles, things like, you know, and I was joking with Palmer, and this is no joke. I mean, what edition do you have? The Mallet book? Is it the 8th edition now? Okay, mine's still tapped up. Mine was the 6th edition. See, I'm old, okay? I'm 38. But the fact is that I used that book when I was trying cases. I used that book when I was prepping witnesses. I mean, the fundamental principles like primacy and recency, that if you read the book in a reading assignment, you'll get. And we have a setting for that in the Army. whether it's a trial or whether it's talking to a client, you have to be willing, have to be able to communicate your argument. As an attorney, you'll make arguments. That is what we do. You make an argument as a zealous advocate on behalf of your client. You should be good at it. You should hone your skill. You're paying a lot of money to learn these skills. When you leave Widener, hopefully you'll be blessed that clients will pay you a lot of money to make an argument on their behalf. That's important. And it's important no matter how, if you're top of your class or bottom of your class, you can do better and you can work at this because it's a skill. I'm still learning every single day. I'm not perfect. And I will never be perfect. But I strive to do better every day, and that's a skill that you have to recognize. That's why, frankly, when I was joking with Martin, I said that's why when I was a first year, when I was at Widener, I knew I wanted to go back into the Army, in the Army Jaguar. I joined the Army at 19. And I knew I wanted to try cases. For me, I don't know if it was because I saw a few good men in the movie too many times or what, but I knew I wanted to try cases. I knew I wanted to be in the Jaguar. I knew that it was very, very competitive. And I said, okay, when I graduate Widener in 3 years, what's it going to take to get in there? And also, what is the best experience for me, why I'm at Widener, to get in there? So after my first year, when I was here, I worked with Wherry and PPR, and I know there's different courses now, I don't know, but that's what I took when I was here. I knew that the Jaguar hires, that's where you get a lot of litigation experience and basically trial experience. I knew that they looked at experiences in the district attorney's office very favorably. As a first year, I had an offer from the Attorney General's office here to stay here in Harrisburg and to make $10 an hour, which I thought that was a lot of money. I don't know, probably not a lot of money now, but that to me was a whole lot of money. Or I could take a job on work study in the Philadelphia DA's office, where I wasn't really getting paid, but I could pay off some of the loans off. I took the job that was non-paid. So I knew if I was in front of the DA's office, I'd be in court every day, which I knew was a skill I wanted to do. So I would say to you that if you think that maybe you want to be a trial attorney, if you want to be a prosecutor, if you want to be in court every day, whether as a prosecutor or a defense attorney, you gotta want it. If you don't ever want to do it, that's fine too, but the skills that you learn this week are critically important. I know this is day 5 of 7 days. And I know these days are very long. You have to get dressed up every day. What a pain in the ass that is, right? For guys, it's easy. You usually have 1 or 2 suits. You just keep your shirt. My wife's a lawyer, so she complains all the time. She's like, you wear a navy blue suit. I have 5 navy blue suits, pretty much all the same, all from Brooks Brothers, and I have different ties and different shirts. And I just got these new shoes last night, so they're pretty shiny. But TMI, too much information. But I remember being here at Widener, and I had professors like Jim Dean, who was brought from a U.S. attorney for the Virgin Islands. And I remember just, seeing him at court, or seeing him in class every day, and he was in navy blue suit, and I was like, well, that's what you have to do. That's what, that was my regular reference. Why you do these things, and I'm going to talk about some of my experiences, but when I say you got to want it, and I'll gladly talk to anybody, after, I'm going to stick around after this is over. But when I say you have to want it, it's not easy. I circle, next thing you know, they're fighting. It looks from the crowd that maybe this girl, Deidre Frazier, just punched Krista in the stomach or something because she fell down and went to her knees. What really happened was Deidre Frazier took out a knife that no one saw, and she stabbed her through her breastbone into her heart. And Krista Lewis, a 16-year-old girl, died. Now, when I was at Widener, I didn't know, that was my neighborhood in Northeast Philadelphia where I was born and raised. I didn't know either one of them. When I was in the DA's office, I saw that it was, the trial was coming up on the news, it was a big deal. And I remember saying to my boss, hey, I got my work done, can I go to the court and see what's going on in the case? I was in the homicide division. And my boss said, hey, just spend a few hours, I don't need you back for 4 hours, go ahead. So I'm there in court before it starts, I go up to the DA, who I never met, and I said, hey sir, I'm Patrick Murphy, I'm one of the interns here at the Philadelphia DA's office. I said, if there's anything that you need during a trial, I have permission to be here today and throughout. And he said, thanks Patrick, it's great. And he moved on, he's a pretty busy guy. So I sat in like the second row, I'm sitting there, got there early. Well, opening statements. The defense puts on, the defense attorney puts on, the fact that Krista Lewis may have been in a gang, which she wasn't, which was frankly a surprise for the prosecution because we didn't know of any witnesses or evidence that that was the case, and it wasn't the case. But he started making that argument. And you all know about the theme and theory of the case. The theme being a bumper sticker, the theory being your side of the story, your version of events. Well, all of a sudden, I'll never forget there, the DA looks at me, he's retired now, looked at me, and he wakes me up. He said, go to the law library, figure out all the research you can on what's admissible gang-related case law, in case we have to defuse what their argument is. The opening statement, the saying, you get one chance to make a first impression. Opening statements are critical. Having a theme and a theory of a case, the bumper sticker of the case, is critically important. Now, I've seen some great attorneys, and I've seen some really bad attorneys. When I was here at Widener, I was blessed to be on the Trial Advocacy Honor Society, and to be on the trial team. It was called the U Pierce competition, where it's Harrisburg versus Delaware. We kicked their ass every time. The colleagues over in Delaware. As Professor Locker mentioned, I was in the trial team that we went and competed in Atlanta. I'll never forget at one of these competitions, not in Atlanta, but prior, that one of my classmates, the theme of the case was, this case is like a cookie, and it's crumbling. I remember being like, that is a horrible theme. And, this case is about a cookie, and it's crumbling. It's like, trials is really the intersection of life and a law. They're dramatic events. You have to let a judge know and a jury know why it's important. You have to grab their attention, and you have to show that you care about it. You care about your client. You care about your version of events. In every way possible. So, as we talk about openings real quick, let me just ask real quick. How about, what's the criminal law case that you guys are dealing with here?
People versus Grabowski.
What's that?
People versus Grabowski.
People versus Grabowski? All right, so what's your name, man?
Stephen Starr.
Stephen Starr? There's like a restaurant named Stephen Starr. Sure,
I've heard that, yeah.
Yeah, no, he's a good guy. He's one of my campaigns. So, I don't know if he wears a red, white, blue tie, but I like it. So, Stephen, what's the theme of that case, in your view?
From the defense side or prosecution side?
The prosecution side.
The theme of the case is, this is a case about betrayal. Betrayal of a country and betrayal of an organization.
Okay, what's the theory? The bumper sticker, give me the 5-minute version. Give me
The theory is the Special Agent Max was upset with how his family was treated. He wanted to get revenge on the government.
Okay. And he did it by doing what?
He did it by betraying. He did it by becoming a member of an organized crime outfit and betraying betraying his FBI boss by misleading him into what he was doing and how he was ultimately going to betray the FBI.
Okay. Okay. And what's your name?
Sarah.
Sarah, fight defense. What's the theme of your case in the theory of the safety?
From the prosecution?
No, from the defense.
Oh, from the defense? Oh, sorry. The defense's theory is that I guess basically that
Defense side, so.
yeah. Well, I guess it's basically that the defendant, the verbose guy, is he's a good, he is a, what is it called?
No honor.
Yeah, so he's
That's a
basically,
big
their
deal.
whole theory, yeah.
I got a Bronx Star, it's a big deal. Medal of Honor, it's like, you know what, I recommend that I drink ever in any bar in America. Ever. Yeah, sorry.
So their theory is that he's committed to his country and he always has been, and that his supervisor in the FBI is mad because things went wrong, and so he's trying to get back there.
So shifting. Before you ever get to an opening statement, I'm in the litigation department at a major law firm, as I mentioned. I've been at Cozen O'Connor, which is another big firm based out of Pennsylvania, now Fox Rothschild. In both of these cases, in both of these law firms where I practice, I'm barely ever in court. Because if you want trial experience, it's really, you get it mostly as a criminal prosecutor or criminal defendant. But that goes to show you in the book, again, the fun one, it's a really important book. Determining, again, who determines the facts of the case? The jury who determines the facts. The judge or the jury? The jury. Who determines the law of the case? The judge. Now, in litigation, that's important. Because if you're defending somebody in litigation, if it's a civil case, not a criminal case, you don't want to go to court. It's very, very expensive. I have a client right now who's paid over $100,000 over a dispute with a neighbor. He has a lot of money. He doesn't like that his neighbor is basically operating a business. It's a really wealthy neighborhood in Bucks County. So he's willing to litigate about it. And we charge a lot of money. I don't mean this in a cocky way, but I charge $450 an hour. And the rates are going up. And I'm not even the highest price attorney in my law firm. But because I've been in court, because I've seen it, because I've been through the ranks, I know what arguments need to be made and should be made. When in 1998, you guys know I used to teach at West Point, but before I was a professor at West Point, I was an attorney at West Point. I was a prosecutor and I had to control full litigation. So we had a hospital, so there's malpractice cases, I had doctors, but also there was slip and falls. We have 1 million visitors a year at West Point. And then when it rains, people fall, someone leaves, etc. In 1998, there was the Army-Navy game. That's at West Point versus midshipmen of the Navy. Usually in Philadelphia, the old football stadium in Philadelphia, where I used to be an Eagle security guard at age 16, was all 120 pounds. I was really, really tough looking then. Unfortunately, in 1998, there was cadets that were there at the game. Cabins were spanning. The cadets were going crazy during the game. They're rounding the falls and breaks. Cadets, a few of them got really seriously harmed, including one that broke his neck. He couldn't go and become an Army Ranger. His dad was an Army Ranger, served in Vietnam. He graduated class of 1999. He couldn't go in, so he sued everybody. And litigation, again, in civil practice, when in these cases you want to go ahead against people that have big pockets. Who has big pockets? The U.S. government, City of Philadelphia, the manufacturer of the railing and the seats, etc. Well, in this case, again, juries and sometimes judges determine the facts in the defense trial. Well, we know what the facts were at but we want the judge to determine, we didn't want to get through OPC, we didn't want to get to court. So my job was to make sure that I could use the law to protect the US government. Now, it wasn't the US government's fault that this cat broke his neck. We basically said, we're gonna take care of this guy, we're gonna pay for his medical expenses. He gets the best treatment that we can give him. But when you sue for millions of dollars, that wasn't our liability. But I used the law to shield in litigation the US government. And that time the defendant was named Donald Rumsfeld, the former Secretary of Defense. Well, there's a legal doctrine called ferries. And your ferries law, basically sovereign immunity. That if you're an official scope of your mission in the military, that you basically can't sue. Like, so if I'm a private in the Army and I have a drill sergeant who yells at me and hurts my feelings and makes me cry, I can't turn around and sue him for intentional infliction of emotional distress, even if he says really, really mean things. Okay? But again, that was making sure that we tried not to go to court. That's litigation. That's, you know, important part of it. But again, in opening statements, and basically whether it's criminal law or civil law, that is your first chance to make a great impression. Please, do never use the theme of a case that your case is about a cookie. I like cookies. I like those macadamia nut cookies. I love them. I get chocolate chip. My daughter Maggie Murphy, she's 5. She makes cookies for my wife and I, and her little brother Jack is 2. When she makes me cookies, it's the sweetest little thing. But no one gives a shit about cookies. Make sure that you articulate that you are presenting a case, a theme, and a theory of a case that people are going to care about, that you feel passionate about. So, all right, let's move on now. I want to talk about direct examination. I think in direct examination, the key is you want to elicit the information out that you need. Now, what's your name? Let me see.
Candace.
Candace?
Yes.
What side of the case do you have? Do you have the civil case or the criminal case?
I'm also an assistant.
Oh, assistant? Okay. All right, well, I don't want to put you on the spot. Who else? Can you tell me your name? Yep.
Ashley,
Ashley? Do you have the defense or the criminal case?
we have,
I'm sorry, the civil or the criminal case?
we have criminal,
Criminal, you defense or prosecution?
we are defense.
Okay. So on direct examination, who's your first witness?
Our first
Or
witness, we're gonna present the defendant first,
the defendant first?
yes.
Okay. And what are you going to try to elicit in direct examination of the defendant?
We're going to elicit that at all times, his only duty was with the organized crime task force. And that he is, you know, duty, honor, loyalty. He's a Medal of Honor recipient. He would, you know, never join a mafia gang after one interaction with the kingpin in a bar randomly at night.
So all these things are where you're going to elicit.
Right.
Critically important. Let me take a step back real quick. You know, obviously he has a right in a criminal case not to obviously testify under what amendment of the Constitution? The Fifth Amendment, right against self-incrimination. Why ITAP is important and why this is important, when you boil down the legal system, our Constitution, the blueprint of our country, and it sets out 3 branches of government, all that stuff, also sets out rights that we all have as Americans, including the right for jury trial, majority of your peers, including the right against self-incrimination, including the right to counsel. Where does the right to counsel come from? 6th Amendment. Also, the right to confront witnesses against you. So if there's, in this guy's case, he always has a right to basically confront his witnesses. That's critically important. I mean, that's why this is why the ITAP program is important. So when you have direct examination, you're trying to elicit. Sometimes it's easy for this guy who's been in the Army for a long time, not a honor winner. You know, he's probably a particular guy. I will tell you that sometimes witnesses, it's hard to get information from. I had 3 cases in the Supreme Court of Iraq when I was in Baghdad in 2003, 2004 as part of the invasion force. I was with a unit called the 82nd Airborne Division. We jumped out of airplanes for a living. where we had a convoy, where it was a deuce and a half, a big truck and like Humvees. We're going down the road, and here's this guy in religious garb on the side of the road with a rocket launcher, and he's trying to blow up our convoy. Well, thank goodness that the rocket launcher malfunctioned. The guys in the deuce and a half, basically a big truck, they see it, and he's there with two other guys. They all have AK-47. Our guys have M4 assault rifles, which is the new generation of the M16. And basically, they start firing, but they drop their weapons. They malfunction. They drop them down. So I'm trying this guy, Sheikh Toma, the Supreme Court of Iraq, because it's a national case, it's religiously. And where in America we were used to principles like rule of law, which means no one is above the law, no matter who you are. In Iraq, this was literally a foreign concept. They were trying to establish a new justice system to show that if you commit a law such as trying to blow up a convoy, that is a violation of the 1969 Iraqi criminal code. So we're prosecuting this guy. So I put one of the guys in the back of the deuce and a half, this private first class, great young guy from Oklahoma. My first question is, Private, can you please tell these justices what your job is? And I say it obviously in English. I spoke very little Arabic. My interpreter repeats it in Arabic so the justices can understand what the heck I'm asking. And then he answers on the 50 cal gunner. Well, what's a 50 cal gunner? I had to, trying to well, he was nervous. I don't blame him. Okay. And oh, by the way, there was like a mortar attack during the trial. They're trying to kill us, which is great. That usually doesn't happen. It's not going to happen here. I couldn't get him off the fact, and I said, well, what's a 50 cal gunner does? And he started talking about the ballistics of bullets, and I was trying to get him back on, like, why were you in a convoy? Where were you going? But you have to practice with your witnesses. Not that you coach them what to say, because that's a no-no, but you have to guide them where you're trying to go. And so part of it is the practice and talking to your witnesses. The 6 P's. Perfect practice makes perfect. Not practice makes perfect, but perfect practice makes perfect. The 3 P's, so I should say, the 3 P's. That's important, not just for this course, but beyond too, because you don't know what's gonna happen. Now, on cross-examination, can you tell me your name?
Katie,
Katie, do you have the criminal case or the civil case?
I have the criminal case.
Criminal case, a prosecution or defense?
Defense.
Defense. So on cross-examination, the government's witness, do you have one that you're gonna,
Yes, Captain Kapowski.
okay, and what are you gonna try to list in cross-examinations?
Basically that, the theory of the case that he was angry that he didn't get his promotion, that he was angry that, that the agent wasn't able to get his brother's role on the head of the mafia group. So those are the 2 main points.
Okay. And how are you gonna ask, what do you think what are you not gonna ask? How about that, cross-examination?
What am I not gonna ask?
Is there something that you don't want him to repeat? He's obviously gonna be on the direct when he's on the government side. He's gonna talk about things the government wants him to talk about. You're gonna hit him on cross. Is there anything that you say, I don't want him to repeat this, or I don't want him to go into this detail, or I don't want him to elicit a certain fact?
Well, I know I don't want him saying anything about Grabowski having another way to get in contact with him. I don't want him to be able to expound on anything like that.
Okay, so you know what not to answer.
Yeah.
Or if he starts going that way, so easy, because you're right there, you know it, you know, you're a zealous advocate for your side, you're excited, and you want him, you know, it's like, it was a little bit before my time, but the Matlock, moment, where you're expecting the defendant just to be, oh, you're right, you know, it's not gonna happen. Get over it, get in and get out, get the 2-3 things you need from him, add it to your arsenal, what your argument is, the theory of your case, and move on. But as I said earlier, it's critically important to know and be ready for the unexpected. You don't know what that person's going to say. When you go through this course and you're having the trial, you're going to have some witnesses that are going to say things that maybe aren't exactly what the fact pattern says. What are you going to say? When you, one of this is Saturday, right, or Friday? You know, Friday. Like, get ready for that, because it's going to happen. One of you jerks is going to go away from the fact pattern, okay? All right? And you got to be ready for that. Objection, whatever, you know, whatever the argument's going to be. I will tell you that I sometimes had to learn the hard way. I had a case, so before I joined the faculty of Westport, I'm there as a prosecutor doing court martials, but I had all the federal lands up in New York. Well, I had one case where it was the VA hospital, so civilians that commit crimes on military bases or federal land, I had to prosecute. If they're civilians, we don't have jurisdiction over them in military court martials. They're not in the military. With civilians, we would try them in federal court. So on the days I was in federal court, I was in a civilian suit, even though I was on active duty in the Army. When I was in court martial, I had the what's called Class A uniform, a lot of bling bling, shiny stuff. But the other days I look like this. Well, I had a case where the defendant, who was a criminal, assaulted a nurse. Now, he's probably a little mentally unstable, frankly. But he assaulted a nurse, and it was a pretty traumatic experience for that nurse. And I had to prosecute him. I didn't think he would take the stand, but he did. When he's on the stand, and I'm in cross-examination, I have to be honest with you, I was roughing him up pretty bad. He started going on this deviation about how in the Irish culture, he also spit at the girl. In the Irish culture, spitting at someone is a sign of warmth. I was like, I'm like, I can't believe this. Palmer did not do this at ITAP. What the hell is going on? Okay? But I was feeling pretty good. I was embarrassed a little bit, which is okay. Because I wanted the judge to understand that this guy was full of it. And then he said something that I'll never forget. It's a case where he assaulted a nurse, where he threatened her, and on the stand, he didn't take the Fifth Amendment, obviously. On the stand, he threatened me, the prosecutor. He said, why don't we take this outside and have a conversation about this? And I said, sir, can you repeat what you just said to the court? And he said it again. And then I said to myself, do I recharge this guy? Like, and I'm like, in my head, I'm like, I can't believe this just happened. The court, the justice, the federal judge basically said, not the justice, he's a magistrate judge, basically says, time out. We're going to take a 15-minute break. What happens is that basically they had to do an investigation if that's what we're going to move forward. He didn't want to have to do all the paperwork. He's like, I want to settle things down, let's just move forward. And we move forward. Now the police officers in the back of them were taking bets on how long it would take to put this guy down if Captain Murphy actually fought this guy. So, but that didn't happen. But we got the conviction. But again, you know, in cross-examination, you got to be ready for the unexpected, especially in cross-examination. And whether that is Friday during a trial, or if you go to practice, you got to be ready. But you also have to remember to get in and get out. Don't ask too many questions. If you ask that one question or you leave it open, you know, you want to elicit a yes or no question. You want to ask, obviously, leading questions on cross. Not doing. All right. Let's talk about one of my favorite things to talk about. I'm sure it was very, very exciting for you to have to deal with this. And you've already done after you did on day 2 of the ITAP course. Admitting evidence in a law. Okay? Admitting into evidence documents. Isn't that exciting? I think it's awesome. I remember when I was going through it, I'm like, this is the most I was using as at court martial at Fort Bragg, North Carolina. And I will tell you that in that case, it was a stealing from the government case. We had a buck sergeant in Iraq who was stealing computers that were shipped over to us in a forward operating base in south central Baghdad. It's 138 degrees in 2003. We don't have showers. We didn't have latrines for the first part we were there. We didn't have hot meals. We had like one computer. Now, I'm in charge of the justice system for 1.5 million people. Imagine being in charge of a justice system and not having enough computers to have. Imagine paying out over $1 million in claims, some wrongful death cases, where there was people that were killed, where you're trying to make what's called salation payments, which are, even if we were not at fault, they, as an expression of sympathy with having you pay, well, if you put American taxpayer dollars and give to somebody, you better have that documented, you better have it signed by them, you better have, your paperwork, because otherwise, guess what happens? They come back after you. And that's just in the law department. Imagine the other stuff that we needed. We had a sergeant that basically stole computers when he was over in Baghdad, and basically never said that he had them and went back and sold them in the black market over there. Okay? Was the theme of my case, this case about stolen computers? Was my theory, obviously the theory about what the argument was, but, the theme of my case was dishonoring those who gave the ultimate sacrifice. Because when we were winning hearts and minds, the shock and awe part of the war in Iraq, that's when Christine Amalpour and CNN and Fox News, Ollie North were embedded with us. We're kicking down doors. It was really cool. And they covered that stuff. But winning hearts and minds, rebuilding schools, making payments when we were wrong, whether it was kicking down the wrong door or getting in a car accident, we were showing that we're not above the law either. If we were wrong on something, we would pay. Well, that was a lot harder when we didn't have enough computers on the ground and toner and all that stuff. Because there was a sergeant who was 23 years old that was trying to make a couple extra bucks. And the 19 guys that I served with who gave the ultimate sacrifice, they never made it home. You remember he was dishonored by the sergeant because it was about greed. And that whole case about stealing government property basically had to be made in putting statements and documents and evidence. And guess how I did it? When we came back to Fort Bragg, North Carolina, that's when we prosecuted. These document after document after document. I was just taking out the textbook that I had from ITAP. So, because when I graduated from Widener, and then I went to the JAG school at University of Virginia, School of Law, because that's where the Army JAG school is, we didn't have intensive trial advocacy. We had a 2-day course, but luckily I had the foundation that I learned here, I was able to use. And then when I was back out trying these cases, that I was actually using documents in front of myself for that trial, where we got a conviction. I know it's boring. I know that's difficult. But it's one of those things that you need to grasp and need to understand now. And whether you never try a case, those fundamental skills that you learn are important down the line. All right. Do I have any questions today? All right. Let's now talk about closing arguments. Closing arguments are the things that you should be doing before anything else. This is your final argument that you're making. You're going to talk about the evidence that you have. This is, again, when I talked earlier on about the fundamentals, primacy and recency. They're going to remember the opening statement, they're going to remember the closing statement. The stuff in the middle, you'll be surprised. Juries pick up on the smallest thing. I am a little bit old school because, again, I was here this class 15 years ago before ITAP. So I still do the legal tab. And that's what I use when I'm at trial. Now, I think it's helpful because juries don't have laptops. you want to talk about what was said earlier in the trial, things like using words that they say on cross-examination, or even direct examination of your own witnesses, what you want, the evidence that you want to get out, or that you've got now, you want to make sure that they remember. Have it on a legal method. Use exactly what they say. You heard this person say on last Wednesday, or you heard him say it yesterday, you heard him say 3 hours ago, that X, Y, and Z. It's important to have that ready and use that in your closing argument. Again, going back to your theme and theory of the case. That's important. It's important because that's your last chance to win. As I said earlier, trials is the intersection between life and the law. It is a dramatic event. You know, frankly, trials 200 years ago in our country were like the entertainment for society. That's, they used to go to the courthouse to pay attention. That was like, it was like a show. It wasn't a show, it was real life, but that's all I saw. But that's why it's important to hone these skills now. Because it's not like you're going to learn it. It's not like you're going to go to law firm, you're going to pay a lot of money to reteach you this stuff. You're going to be expected to know it. Whether you're in court, whether you're helping a partner in a law firm prep for court. It's a value added to an organization. And that's why it's important, when you talk about closing arguments, to get it. To understand what's your bumper sticker of the case. What's your theory of a case? The theme and theory. And utilizing that theme and theory when you're in direct examination, when you're in cross-examination, when you're putting exhibits in evidence. But especially when you're giving your closing argument. It's critically important. So, what's your name back there?
Hugh,
You? Are you the civil case or the criminal case?
civil case,
And are you, who do you represent? Do you represent Robinson or Flightworthy?
the plaintiff, sir.
So that would be Robinson,
That's correct.
okay? And what's your theme and theory of the case?
The theme and theory of the case is that the accident was caused by a faulty switch, that the company had knowledge a year prior to the crash that the switch was faulty, and that the talk about Mr. Robinson's marriage, the problems with his bank are merely distractions, and that the defendants can't prove that the switch did work, but they did know that it could fail, and they did nothing to act on that until it was too late.
So they're trying to get to the, basically make him disparage his credibility. Again, I didn't leave the backpack. I mean, basically, there's some marital infidelity going on or something. So it's like the John Edwards case, is what you're trying to tell me. Okay, I mean, that's a real life example. I mean, the John Edwards case, the third theme of the case is, this is the law, is what you're judging on, not the Bible. John Edwards cheated on his wife, he did some horrible things, but he did not break the law, the federal election code. And as an analogy, that's basically what you're arguing.
Yes, sir.
Because he didn't break the law, or that he may have had marital infidelity, or he may have had issues. That's irrelevant to the case. They're trying to distract you. They're trying to show you this shiny thing over here that has nothing to do with the life story.
That's right.
Who's on the other side in here? On the other side?
Yeah.
And what's your closing argument?
Closing, my
What's
closing,
your theme of the case?
my theme kind of is this guy had it all, and because of his actions, he lost it all, and it just overbore him, and for that reason, it wasn't a defect in sound product of Flightworthy, but rather it was his intentional actions of crashing the plane, which can be proven by the discussions he had with his mechanic, and the fact that his bank was multi-million dollars in loans, which inevitably closed, and is being investigated in the FBI, and that he would eventually have to face all this. And because he was such a high-standing member of the largest bank in the community, as a deacon, as all these other things, that he wouldn't be able to do that, so he took the easy way out.
So that's your theory. Your theme is what's the bumper sticker of the case? I
That
know this is not easy.
pretty much that
shattered illusion because he didn't have the math. And you heard from Mrs. Jones, it's a shattered illusion because like use your theme when you're articulating your theory of the case as much as possible. It gives you more credibility. And it reinforces your argument. And that's critically important. Listen, you all care about this case. You all care about the cases that you're doing. You care on the defendant side, you care on the plaintiff side, someone cares about the government side, someone cares about the defendant side of the criminal case. You care about it, you know it. The jury has to be there. They care about getting out of there as soon as possible so they can be back with their families. A judge is thinking about when is my tea time, when can I get this case over with? You have a short time, and they're not going to pay attention to every single word. It's human nature. That's what makes this hard. It's not easy. That's why you have to reinforce, you're going to say what your theme of the case is, then you're going to articulate your theory, but you can't remember, oh, well, I said what my theme is, so he's going to know what my theme is. You got to repeat what your theme is. Remember the earliest thing I said to you. Tell them what you're going to say it, and tell them what you just told them. It's really simple. When I ran for the U.S. Congress in 06, I used those, I talked about three things ad nauseum. I talked about the Iraq War. I talked about earmarks to Teapot Museum, which I don't think was really that imperative to fund. And I talked about stem cell research. Because even though I'm Catholic, I think that we should invest in stem cell research. I think people are counting on it. And my opponent disagreed with me on all those three things. And my argument was that the change Washington, the change we said on Washington. And not just why he should be fired, but why I should be hired. Because there's a difference when it comes to the Iraq War, when it comes to stem cell research, when it comes to wasteful government spending. That was the argument that I made. I could have talked about 20 things. When Al Gore ran for president against George Bush back in 2000, he talked about 20 things. Al Gore didn't win because he talked about 20 things. Now I understand there's different fact patterns and there's things you got to bring out. Don't get me wrong. But you got to boil down to 3 or 4 things. Your theory about whether it's the marital fidelity, this is the evidence, bang, 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 and this is the financial issues, bang, bang, whatever it is. You got to make sure that the judge and or the jury gets it. And you have to make it easy as possible. You have to repeat it. Because again, primacy, recency. These principles that you're reading about, that you're going through this exercise on, I know you're saying, well, it's theory, this course is really important. And you heard me say in the very beginning, I wasn't saying this to patronize you. This should be a mandatory course. The fact that half of you in the classroom are here, God bless you, I'm preaching to the choir, and not the whole congregation, but it is what it is. You have a leg up now on your classmates. Because you went through this course, you have a leg up on basically the colleagues that you're going to compete for jobs against. Let's face it, what is there, 6 law schools in Pennsylvania? University of Pittsburgh, Duquesne, Widener, Dickinson, Penn State, whatever they call it these days. Okay, Temple, Penn, Villanova. And now Drexel, 8 schools. Okay, that's who you compete against. What are the best trial advocacy schools in Pennsylvania? The 8. Widener and Temple are known as the 2 best trial advocacy schools there. Part of it is because they have courses like this. So knowing that going into it, what are you going to do about it? How are you going to use it? And again, whether or not you practice as a litigator or you don't, it's a skill set that you learn here that they're not getting taught at other places. Or at least not this deep. And again, I know I'm preaching to the choir, but make sure that your classmates, because listen, when you're all mostly second years or third year static division, the fact is that next year your classmates, after they graduate, they're not going to take this class their third year after they graduate. So they're not going to be there. They're so worried about the bar exam, as they should be. But I applaud you for being here and caring enough about it. they did was bitch about Widener. This law school sucks, Chiefs down the street sucks, like, it's like, hey man, you know what sucks? Being in Iraq, that sucks, right? So, that sucks. This is a great school. There's an incredible opportunity. You know, I didn't talk about like me being at Fox Restaurant, billing $14 an hour, like as a like I am great. I'm telling you, that's life. Like I've been very blessed. I've been very lucky. That's why I left my kids and my wife this morning at 5 o'clock in the morning to be here. I was at the Starbucks down the road prepping what I was going to say to make sure that I shared with you what I thought was important. So use this example, use this experience that you have here at Widener for the better. Whether you go into public service or private practice, you have an incredible opportunity to make a difference. Use the skills